1888, the Minnesota Supreme Court considered whether the state legislature could delegate to a commission the authority to set rates for common carriers that are, quote, equal and reasonable, close quote. The court explained the common understanding of the time as follows. The legislative department, to whose judgment and wisdom the high prerogative of making laws has been entrusted, cannot relieve itself of the responsibility by choosing other agencies and substituting their judgment and wisdom for its own. Despite their paean to the non-delegation principle, however, both the Ohio and the Minnesota Supreme Courts and several others upheld the challenged delegation of authority. In J.W. Hampton, the Supreme Court followed suit, first extolling the non-delegation doctrine and then upholding the challenged delegation. Quoting the Ohio Supreme Court, Chief Justice Taft explained, "The true distinction," he said, "is between the delegation of power to make the law, which necessarily involves a discretion as to what it shall be, and conferring an authority or discretion as to its execution, to be exercised under and in pursuance of the law." Then to operationalize that distinction, Taft declared the Congress may authorize executive agents to carry out its legislation as long as the Congress, quote, lays down by legislative act an intelligible principle in which the person or body authorized is directed to conform. Despite Taft's careful line drawing, the Supreme Court has invoked this principle of non-delegation to strike down an act of Congress exactly 2 times. Both in the same year, both with respect to the same act, the National Industrial Recovery Act of 1933. Section 9C of the NIRA authorized the President to prohibit the transportation in interstate commerce of petroleum products produced in excess of the amounts permitted by state authority, but did not define the circumstances under which the transportation was to be prohibited. The President was left to adopt his own, quote, code of fair competition for the petroleum industry, close quote, to guide his decisions. And in Panama refining, the court adjudged Section 9C an unconstitutional delegation of legislative power. Here's what they said. The Congress has declared no policy, has established no standard, has laid down no rule. There is no requirement, no definition of circumstances and conditions in which the transportation is to be allowed or prohibited. This section gives the President an unlimited authority to determine the policy and to lay down the prohibition as he may see fit. Later that same year, the court considered the Code of Fair Competition for the live poultry industry, which, pursuant to the NIRA, had been proposed by the industry and adopted by the President in an executive order. And most of you are familiar with this case, Schechter Poultry, in which the court unanimously held such a delegation of legislative power is unknown to our law and is utterly inconsistent with the constitutional prerogatives and duties of Congress. Justice Cardozo, who had dissented in Panama refining, now famously declared, "This is delegation running riot. No such plenitude of power is susceptible of transfer." These decisions had momentous political consequences. The NRA, the National Recovery Administration, halted operations. The Congress stopped working on New Deal legislation and looked to the White House for a response to the court. President Roosevelt did respond angrily, denouncing the court for crippling the federal government and imperiling the nation. "We have got to decide," he said, "whether in some way we are going to restore to the federal government the powers which exist in the national government of every other nation in the world." And a debate emerged in the public press about judicial review and the role of the court. And academics deliberated over whether the court's rule against delegation threatened to defeat the efforts of our political democracy to use government as an instrumentality for the effective control of our national economy. Ongoing confrontation with the political branches appeared too perilous a course for the court. And though it's never overruled Schechter or expressly repudiated the intelligible principle standard of J.W. Hampton, its standards for intelligibility have become so flaccid that the Congress may now delegate authority to regulate the private sector, quote, in the public interest, convenience, or necessity, or even to be generally fair and equitable. My colleague Steve Williams and I played a modest role in the last gasps of the non-delegation doctrine in the American trucking case, where our court considered the provision of the Clean Air Act that requires the EPA to set a national ambient air quality standard for pollutants at a level, quote, requisite to protect the public health with an adequate margin of safety, close quote. And because ozone and particulate matter are non-threshold pollutants, the EPA lacked a determinate criterion for setting any particular limit. We held there was no intelligible principle in the Act to govern its decisions and remanded the matter to the agency so it might, if possible, construe the Act to provide an intelligible principle by which to govern its own decisions. But on further review, the Supreme Court concluded no such construction was necessary because the phrase requisite to the public health was determinate enough in view of the precedents upholding regulation in the public interest. As the court explained, we have almost never felt qualified to second-guess Congress regarding the permissible degree of policy judgment that can be left to those executing or applying the law. True, of course, but why? If non-delegation was so fundamental to our constitutional order, why did it have so little a constraining effect? Why are there only 2 cases from some 75 years ago in which the court has found an unconstitutional delegation of legislative power? I submit that the explanation lies in Madison's warning about the predominance of the legislature in Republican governments, or what we might today call the counter-majoritarian difficulty. If we look back to the non-delegation cases on which Chief Justice Taft had relied, we see that the judges' rhetorical enthusiasm for the non-delegation doctrine was overmatched by their reluctance to confront the legislature. In the Ohio case, for example, before the court reached the non-delegation issue, it devoted 1/3 of its opinion to justifying its authority to review an act of the legislature for constitutionality, and this 50 years after Marbury versus Madison. After noting that the legislature is of necessity in the first instance to be the judge of its own constitutional powers, the court explained, if a court were to annul the law while entertaining doubts about the subject, it would present the absurdity of one department of the government overturning in doubt what another has established in settled conviction, and to make the dubious constructions of the judiciary outweigh the fixed conclusions of the legislature. Supreme Court of Massachusetts expressed itself in almost the same terms, announcing its determination, quote, never to declare a statute void unless the nullity and invalidity of the act are placed in their judgment beyond reasonable doubt. Other state courts are of the same diffident view. The Supreme Court of the United States early on expressed a similar hesitancy about declaring an act unconstitutional. Justice Chase had explained in 1796, if the court have such power, I am free to declare that I will never exercise it but in a very clear case. And indeed, it was none other than Chief Justice Marshall, the author of Marbury and the godfather of judicial review, who canonized this deference to the legislature when in 1810 he wrote that before holding a statute unconstitutional, quote, the opposition between the Constitution and the law should be such that the judge feels a clear and strong conviction of their incompatibility with each other. And then in McCulloch versus Maryland, let the end be legitimate and all means that are appropriate which are plainly adapted to that end, which are not prohibited but consist with the letter and spirit of the Constitution, are constitutional. That was Marshall's reading of the necessary and proper clause, but consider the violence it does to the text. Necessary and proper is the language of strict scrutiny. The Congress may pass laws that are necessary to secure a proper governmental interest. Whatever is not necessary is not authorized. Marshall, however, transformed the clause into a species of rational basis review. The Congress may pass laws that are adapted, which is to say rationally related, to any legitimate government interest. And so the constitutional presumption of liberty, as Randy Barnett of Georgetown calls it, was reversed. Instead of adhering to the constitutional design of limited and enumerated powers, the view that what the Constitution does not authorize the national government to do, it prohibits the national government from doing, the courts decided, rather than confront the legislature, that the national government may do whatever the Constitution does not prohibit. And who can blame them? It would take some nerve for a judge armed only with the power to persuade to tell the people that a law duly adopted by the legislature and signed by the executive will not be enforced because it is not, in the judge's opinion, necessary, but merely expedient. And so the counter-majoritarian difficulty doomed the necessary and proper clause, and along with it, the non-delegation doctrine, long before the court said the last rites.